Okay. Let's see, we're now back on the record. Cause number 22549, State Mississippi versus William Edwards. And we're going to proceed with the consideration of the jury instructions. The court provided 6 instructions for consideration. Excuse me. Oh, sorry. I'm sorry, Ms. Mullinex is not here. I'm waiting.
Yeah.
Okay. It's just a DA for it. Yes, dear. All right, so Mr. Mullinex is not here. We're not going to take up the jury instructions. The court has provided 6 instructions. I did have to add a 6th instruction to my file because I noticed that there was no instruction provided in regard to the defendant's constitutional right not to testify at trial. The court is going to give all 6 instructions from the court. Is there any objection by the state?
No, Your Honor.
Any objection by the defense?
No, Your Honor.
Moving on to the defense instructions. The court is going to give the one, oh, wait a minute, I'm sorry. I meant the state's instructions first. I do the state before the defense, I'm sorry. That was out of order. The state provided 8 instructions.
Correct, Your Honor.
Okay. All right, so S1 will be given. S2 will be given. S3 and S4 are similar in instructions, and the court will take under advisement before deciding which one of S3 and S4 will be given. S5 was refused. The state has amended their S5. The parties stipulated as to the prior convictions. In the original instruction given by the state, it had the charges listed. The amended instruction will be given. S6 will be given. S7 is given. And S8 is the form of the verdict, and it will be given. To the defense, are there any objections to the state's instructions? Give me S3.
Court's indulgence, Your Honor. No objection. Your Honor, if I may be heard.
Now, we need to look at S3 and S4.
That's what I was going to ask you about.
Okay, the court is inclined to give one of those, but not both of those. The court thinks it's the court's opinion that it's over instructing. We don't need both of them unless you have a rationale as to why you want them to be both.
And if I may, Your Honor.
You may?
S3 is the permissive instruction that can be used when a deadly weapon is there. So malice aforethought or intent to kill can be inferred when it's a deadly weapon. S4 was simply just the definition of a deadly weapon. So my request would be that if the court did feel it was more, then maybe S4 would be the one to drop out. That's just the definition of what a deadly weapon is. But in this case, it was a gun, which I'm sure everyone in the jury would understand that's a deadly weapon. But S3 we would strongly need, because that's the permissive inference the jury is allowed to draw from the use of that weapon.
give S3, and S4 will be refused. All right, let's move to the defense instructions. Any objection to S3 being given?
No, Your Honor.
Let's move to the defense instructions. D1 will be given. D2 is a duplicate of S2, deliberate design, and that is refused. S3, there was no, D3, I'm sorry, is refused. There was no evidence of alibi presented. D4, will be given. D5 is refused. The court is included in the court's instructions in regard to, and this is confusing. D6, okay, D6 is given. D7 is refused. It is an incorrect statement of the law. And D8 is refused. It's a presumptive instruction. It does not. And it's refused. All right, so now to the defense in regards to the instructions that were refused. D2, deliberate design.
Your Honor, we'll, I mean, it's duplicative, and I understand that. The D3, Your Honor, will, I believe that he filed notice of alibi, but I do understand. But I would say that the evidence does show that there was only, I would say that there was only one eyewitness that, in her testimony, for whatever value you want to give it, it's the only thing that was remotely placed in that place. Everything else shows that he was not there. And that's what we're using alibi for, is that he was just not there. He was elsewhere. I think that it should be given. But
What says the state?
Your Honor, the appellate courts have been clear in several cases. One is Sims versus State, which is 213 Southern 3rd 90. Another is Golden v. State, which is 323 Southern 3rd 1122. And another is Body v. State, which is a 24, and I don't have the regular cycle, it's 24 missing appeal Lexus 14. And I apologize because it just came out in October this year. And then they go back to an Owens v. State, which is 809.
Can you give me the reference?
And I apologize, Judge. But what those cases say for alibis, and there has to be an evidentiary basis for it. It can't be a self-serving statement that's made by the defendant. So there has to be testimony and evidence placed into the record that would show that he had an alibi at the time of the crime. And it also goes one step further to say that it's not just an alibi, but an alibi is a physical inability to perform the crime. And so that it even goes broader that he would have not even been able to do it because of this alibi. So none of that comes into the record. So shorten it up, judges. There's been no factual basis for the instruction at all.
Okay. Well, based on that information, the court is refusing D3. There was not credible evidence placed before the jury in regard to the alibi. And it also requires a notice, and I don't recall a notice ever being found of intent to use alibi in this case.
if you look at the transcript, Your Honor.
That's not sufficient proof of alibi.
Yes, Your Honor. Okay. I would just point that in the record, both the defense and prosecution stated that they had received notice of alibi on July 27th, the beginning of that trial.
Okay, well, I may stand corrected on that, but nonetheless, based on the proof that the court heard during the trial in this case, there was not sufficient evidence to provide to establish alibi in this case. This is more about, it would appear, the credibility than an alibi. All right, what says the defense about D5?
The D5 will, but I'm not going to argue that one. That I understand what your argument is. But on, Your Honor, in D6, I understand that the circumstantial evidence.
D7 is
Oh, sorry,
D7.
D7, I apologize. The D7 is circumstantial evidence instruction, and I do understand, and put in there behind there a case site that does, in Wlbt state, does allow, that it does refuse a 2-3 instruction, but it does say that in a case, and this may not be completely on point, but I think it should be included, that in a case based entirely on circumstantial evidence of an instruction allowing this evidence must include every reasonable theory other than that of guilt that is held in violation of that 2-theory instruction of refusal of the latter is non-reversible error. But, Your Honor, again, while there has no been confession and there is an eyewitness that did testify, I would put to the court that eyewitness's testimony is not exactly 100% credible, but if you were to remove that eyewitness testimony, everything else the state has is completely based on a circumstantial evidence basis. I always ask the court to reconsider allowing that circumstantial evidence instruction to include.
Who says the state?
Your Honor, two things. One is, I believe that this case is not a whole circumstantial case. We have an eyewitness, so that would take care of the first prong. The other prong is Wlbt state, which is 325, Southern 3rd, 627. The Supreme Court of Mississippi has done away with circumstantial instruction.
All right, the Supreme Court has reversed this instruction. The courts now have instructed the trial courts that circumstantial and direct evidence have the same weight and to no longer give the particular circumstantial instruction provided by the defense in this case. And that is the reason. It's an incorrect statement of the law. So that's why D7 was refused. All right, D8 was refused. What says the defense?
Your Honor, that was a peremptory instruction and to preserve the record for appellate purposes.
All right.
Your Honor, if I may convert on D6,
You may.
it was granted, but I didn't get a actual citation or authority. I didn't know where that even came from. No. Because I just never seen that instruction, and I couldn't find any authority.
What says the defense?
Your Honor, to be honest with you, I've used that quite a handful of times with no pushback from the state. I would have to stop and go back to the case sites to pull it, but those are instructions that have actually come from public defenders. But Your Honor,
Well, typically, let me just say this, typically, you may have,
but I understand, I do not have a case site.
okay. That's why we require that I like for attorneys to have those index to help me to know the citations. It's not a problem. It's not a problem. The instruction tends to mirror that, just stating that he does not have to prove his innocence, he does not have to prove anything. The court, in reading it, interpreted it that way, although the court had not seen it, the instruction reads, the court instructs the jury that if you believe from the evidence that maybe some other person committed the crime of which William Edwards is charged, and the name of that person has not been disclosed by the evidence, Mr. Edwards is not required to show the name of that person. And it just says that if they think someone else did it other than him, he doesn't have to produce the name. It's no burden on him to produce an identity of that person.
Your Honor, our only position, and I do appreciate you explaining that because I was a little confused with it, but that would be consistent and it's covered elsewhere in their D4. It talks about one evidence, the lack of evidence, and then also I know that there's another instruction in here that says that the burden of proof is on the state. So each and every one of those elements that instruction has been covered elsewhere is proper form of fashion.
Let me take that under advisement for just a moment. Okay. All right, so I'm gonna need just a few minutes for us to reconcile and put the instructions in order. Give us what? 15 minutes? And we'll be back to start the closing arguments. Please let the jury know, Mr. Lewis, in about 15, 20 minutes, we're ready to start.
All right.
looking, trying to find some authority for D6 or something similar, and I couldn't find anything. It didn't fit into any category.
I did find the site.
You did?
Yes.
Okay, what did you find?
Harper v. State, 463, Southern Second, 136.
And do you have a copy of the case with you?
No, ma'am, I was electronic, but it's available on, Time Hall, that case.
Well, here's the problem I have. The court had assembled the instructions, and I was not going to give D6 because I couldn't find anything and didn't provide me any authority as to the legal reasoning behind it. But it's not an elements instruction. It's not an instruction on the weight. It is an arguable issue. It is a proper argument to make to the jury. But I don't think failing to instruct the jury on, I don't think it's going to reverse anything about this case.
Well, if I may, in Harper v. Harper v. State, forgive me. There was a very on-point issue here where there actually were two competing alibi instructions, one from the state and one from the defense. And there was the issue on appeal was, did the judge err in not granting the defense's instruction? And that case says in there that if there was one that already properly instructed the jury, but if it had not been in there and they failed to grant the defense's instruction, they would have reversed. And that's just a paraphrase of the case, but I can read it for you.
But the court's not giving an alibi instruction at all, either for the defense or the state.
Right, but that, and the second thing I would just bring up also in line with this is that it's Brown v. State, where it's a simple instruction that the defense is entitled to jury instructions that support the theory of the case, and the evidence does support this particular instruction.
All right, so noted. The court still will state your objections will be noted for the record. However, once again, the court will state that that is one of the reasons the court requests that counsel provide your authority with your instructions.
Yes, sir.
So that the court has an opportunity to review it. This is not a case involving alibi. The court perceives it as a case involving credibility. However, it's not. There's nothing in this case that would shift the burden ever to the defendant, and none of the instructions do that.
Yes, sir.
All right. Anything about the statement?
Your Honor, just very briefly, if I might. And I don't know how else to say it, but just to say it. Despite very able co-counsel trying to assist the defendant, he has shown during this trial an inability to perform as counsel without ad-libbing, without attempting to testify. And we really expect the same in closing argument. There were several things that Your Honor admonished him about outside the presence of the jury. One of them was the search warrant, and there's nothing, the search warrants. There's nothing in the record to question any of the search warrants. And I can just, the relief I'm asking is maybe an instruction or admonition on your part, Your Honor, because what we don't want is to get up there and say, they wouldn't let me get in evidence of DNA or no DNA. They wouldn't let me get in certain pictures from the apartment. They wouldn't let me say all of this. And we don't like to interject in closing arguments, and we feel like that it might kind of devolve into this free-for-all in closing. So with that, Your Honor, I'll see you.
Your Honor, if I may, me and Mr. Edwards have engaged in some lengthy conversations about closing statements, and he understands very clearly that he cannot testify about this case during this closing argument. The only thing he can address is is evidence that was brought in strictly through the witness stand, and he will not engage in that kind of antics in front of the jury.
All right, so, all right, so closing argument is an opportunity for each side to present their theory of the case based on the evidence that is presented. Each side is allowed to make reasonable extrapolations from the evidence that has been presented. And that is only the evidence from the testimony of the witnesses and those items which have been admitted into evidence. We cannot argue facts that are not in evidence. Closing argument is not an opportunity to impugn the character of any witnesses or any parties equally to the state. There has been, you cannot make golden rule arguments in doing closing arguments or ask someone to make a decision based on a community reaction. Those are improper arguments before the jury. The defendant was instructed as to his right to testify during the trial. I do believe that Mr. Edwards is persuasive enough to understand. He walks a very fine line in not trying to state what he did at any point. Should that occur, the first time he will be warned. The second time, I would quote instruct him to no longer to end his closing argument. So it's not an opportunity. I think he understands that to try to put in evidence not presented to the jury, which would be based how he thought, how he felt, where he was, what he did. It can only be based on what they proved, because the state always bears the burden of proof. You don't have a burden to prove yourself innocent. They have a burden to prove you guilty. And I do believe that you can be careful enough and thoughtful enough not to actually try to testify during the closing arguments and to argue about the strengths and weaknesses of what they have presented, and to not disparage any attorneys or parties or any person in order to present your argument, because that's not what this trial is about. It is about the credibility of the witnesses and the credibility of the state's case and whether or not the jurors believe or disbelieve that evidence and can render a fair and impartial verdict in this case one way or the other. All right. With that in mind, is there anything further from the state?
Yes, Your Honor. One matter for housekeeping. May we approach, or you want me to do it now? The Exhibit 33 was a thumb drive of video surveillance at the 300 South State Street. Played an excerpt that was on another thumb drive that was from that thumb drive. It's in possession of the court reporter, but it wasn't labeled with a separate exhibit number because it's just an excerpt from videos that were on that thumb drive. But since that original thumb drive had a password protection, I didn't know if the court wanted to put that excerpt into as an addendum or something to that other thumb drive. I just didn't know how to handle that. And so I don't know what to do. And so I just.
Well, I can't answer that question myself. The presence of the jury to close the case like that.
Yes, Your Honor.
All right. Let's bring the jury in.
Yes, Your Honor.
one. Stop it. How you spend your time?
All right. Jurors in the courtroom.
Thank you. All right, you all may be seated. Members of the jury, you have heard all of the testimony and received the evidence and will hear the arguments of counsel shortly. I will now instruct you as to the rules of law which you will apply to the evidence in reaching your verdict. When you took your places in the jury box, you made an oath that you would follow and apply these rules to the evidence in reaching your verdict in this case. It is, therefore, your duty as jurors to follow the law which I shall now state to you. You are not to be concerned with the wisdom of any rule of law, regardless of any opinion you may have as to what the law ought to be. It will be a violation of this one duty to base your verdict upon any other view of the law other than that given in these instructions. You are not to single out one instruction alone as stated in law, but you must consider these instructions as a whole. It is your exclusive province to determine the facts in this case and to consider and weigh the evidence for that purpose. The authority thus vested in you is not an arbitrary power, but must be exercised with sincere judgment, sound discretion, and in accordance with the rules of law. Both the state of Mississippi and the defendant have a right to expect that you will conscientiously consider and weigh the evidence and apply the law of the case. It is your duty to determine the facts and to determine them from the evidence presented in open court. You are to apply the law to the facts and in this way decide the case. You should not be influenced by bias, sympathy, or prejudice. Your verdict should be based on the evidence and not upon speculation, guesswork, or conjecture. You are required to use your good common sense and sound honest judgment in considering and weighing the testimony of each witness who is specified in this case. The evidence which you are to consider consists of the testimony and statement of the witnesses and exhibits offered and received. You are also permitted to draw such reasonable inferences from the evidence as seem justified in light of your own experience. Arguments, statements, and remarks of counsel are intended to help you understand the evidence and apply the law, but they are not evidence. If any argument, statement, or remark has no basis in the evidence, then you should disregard that argument, statement, or remark. The production of evidence in court is governed by rules of law. From time to time during the trial, it's been my duty as judge to rule on the admissibility of evidence. You must not concern yourselves with the reasons for my rulings, since they are controlled and governed by the rules of law. You should not infer from my rulings on these motions or objections to the evidence that I have any opinion on the merits favoring one side or the other. You should not speculate as to possible answers to questions which I did not require to be answered. Further, you should not draw any inference from the content of these questions. You are to disregard all evidence which I excluded from consideration during the course of the trial. If in stating the law to you, I repeat any rule, direction, or idea, or if I say the same in varying ways, no emphasis is intended, and you must not draw any inference therefrom. The order in which these instructions are given has no significance as to their relative importance. The jury will receive a copy of these instructions. Members of the jury, shortly after you were selected, I informed you that you would take notes, and I instructed you as to the appropriate use of any notes that you might take. Most importantly, an individual juror's notes may be used by that juror only, and may not be shown to or shared with other jurors. Notes are only a memory aid, and a juror's notes may be used only as an aid to refresh that juror's memory and assist that juror in recalling the actual testimony. Each of you must rely on your own independent recollection of the proceedings, whether you took notes or not. Each of you must formally express your own opinion as to the facts of this case. Be aware that during the course of your deliberations, there might be the temptation to allow notes to cause certain portions of the evidence to receive undue emphasis and receive attention out of proportion to the entire evidence. For the juror's memory or impression is entitled to no great weight just because he or she took notes. and you should not be influenced by the notes of other jurors. Thus, during your deliberations, do not assume simply because something appears in your notes that it necessarily took place in court. The indictment is not evidence. It is merely the formal manner of accusing a person of a crime in order to bring him to trial. You must not consider the indictment as any evidence of the guilt of the defendant or draw any inference of guilt from it. William Irvin Edwards is charged in count 1 of the indictment with first-degree murder. If you find, from a reasonable doubt, from the evidence in this case, that on or about May 1st, 2022, and the First Judicial District of Hinds County, Mississippi, that William Irvin Edwards unlawfully and with deliberate design killed Bobby Carlton Davis, a human being, by shooting him with a firearm, then you shall find William Irvin Edwards guilty of first-degree murder in count 1. If the state did not prove any of the above-listed elements beyond a reasonable doubt, then you shall find William Irvin Edwards not guilty of first-degree murder in count 1. William Irvin Edwards is charged in count 2 of the indictment with felon in possession of a firearm. If you find, beyond a reasonable doubt from the evidence in this case, that on or about May 1st, 2022, in the First Judicial District of Hinds County, Mississippi, that William Irvin Edwards did unlawfully possess a firearm, and William Irvin Edwards was previously convicted of a felony, as stipulated and agreed to by the defendant and the state, then you shall find William Irvin Edwards guilty of the crime of felon in possession of a firearm in count 2. If the state did not prove any one of the above-listed elements beyond a reasonable doubt, then you shall find William Irvin Edwards not guilty of felon in possession of a firearm in count 2. Ladies and gentlemen of the jury, some of you may have heard the terms direct evidence and circumstantial evidence. The court instructs the jury that direct evidence is direct proof of a fact, such as a witness testimony by a witness about what that witness personally saw, heard, or did. Direct evidence is a testimony of someone who claims to have actual knowledge of a fact or who claims to have personal knowledge of the commission of the crime which has been charged. Direct evidence is simply evidence which, if you believe it, directly proves a fact. An example is if a witness testified that he saw it raining outside and you believe him. That would be direct evidence that it was raining. The court instructs the jury that circumstantial evidence is proof of a fact or facts from which you could conclude by your reason and common sense that another fact exists even though it's not been proven directly. Circumstantial evidence is proof of one or more facts from which you find another fact. Circumstantial evidence is simply a chain of circumstances that indirectly proves a fact. An example is if someone is walking into the courtroom wearing a raincoat covered with drops of water and carrying a wet umbrella. That would be circumstantial evidence from which you can conclude that it was raining. The law makes no distinction between the weight to be given to either direct or circumstantial evidence. You, as a jury, should decide how much weight to give any evidence. If death is inflicted upon a person with a deadly weapon in a manner calculated to destroy life or inflict great bodily injury, harm, then malice or the intent to kill may be inferred from the use of the weapon. The court instructs the jury that the law presumes every person charged with the commission of a crime to be innocent. This presumption places upon the state the burden of proving William Edwards guilty of every material element of the crime with which he is charged. Before you can return a verdict of guilty, the state must prove from the evidence beyond a reasonable doubt that William Edwards is guilty. The presumption of innocence attends William Edwards throughout the trial and prevails at his close unless overcome by evidence which satisfies the jury of William Edwards' guilt beyond a reasonable doubt. William Edwards is not required to prove his innocence. The rules of evidence provide that the scientific, technical, or other specialized knowledge might assist the jury in understanding the evidence or in determining a fact issue. A witness, qualified as an expert by knowledge, skill, experience, training, or education, may testify and state his or her opinion concerning such matters. You should consider each expert's opinion, receive the evidence in this case, and give it such weight as you may think it deserves. The court instructs the jury that a reasonable doubt may arise from the whole of the evidence, the conflict of the evidence, the lack of the evidence, or the insufficiency of the evidence. But however it arises, if it arises, it is your sworn duty to find William Edwards not guilty. In this instruction, the deliberate design means a person decides to unlawfully kill another person, and there is no legally justifiable or excusable reason for doing so. The decision to kill a person can be formed very quickly before the actual act of killing. However, deliberate desire cannot be formed at the exact moment of the act of killing. The court instructs the jury to believe this evidence that may be some other person who committed the crime of which William Edwards is charged, and the name of that person has not been disclosed by the evidence. Mr. Edwards is not required to show the name of that person. The defendant has the constitutional right not to testify at trial. You are instructed not to draw any inference from the defendant's failure to testify. The defendant's failure to testify should not in any way be considered by the jury during the course of your deliberations. The verdict of the jury must represent the considered judgment of each juror. In order to return a verdict, it will be necessary that each juror agree. In other words, all 12 jurors must agree before returning a verdict in this case. It is your sworn duty as jurors to consult with one another and to deliberate in view of reaching an agreement if you can do so without violence to your individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. In the course of your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous. But do not surrender your honest convictions as to the weight or effect of evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. Upon retiring to the jury room, you will select one from among your number to act as a foreperson. The foreperson will preside over your deliberations and will be your spokesperson before the court. If it becomes necessary during your deliberations to communicate with the court, please write out your message or question and pass the note to the bailiff. No member of the jury should ever attempt to communicate with the court by any means other than a signed writing, and the court will never communicate with any member of the jury on any subject touching the merits of the case other than in writing or orally here in open court. Bear in mind also that you are never to reveal to any person, not even to the court, how the jury stands numerically or otherwise on the question of guilt or innocence of the accused until after you have reached a unanimous verdict. Final instruction. The court instructs the jury that when all 12 of you reach and agree upon a verdict in count one, you shall return the verdict to the court in one of the following forms. If you find the defendant guilty of first-degree murder, then the form of the verdict shall be: we, the jury, find the defendant, William Irvin Edwards, guilty of first-degree murder in count one. If you do not find the defendant guilty of first-degree murder in count one, then the form of the verdict shall be: we, the jury, find the defendant, William Irvin Edwards, not guilty of first-degree murder in count one. The court instructs the jury that when all 12 of you reach and agree upon a verdict in count two, you shall return the verdict to the court in one of the following forms. If you find the defendant guilty of felon in possession of a firearm, then the form of the verdict shall be: we, the jury, find the defendant, William Irvin Edwards, guilty of felon in possession of a firearm in count two. If you do not find the defendant guilty of felon in possession of a firearm in count two, then the form of the verdict shall be: we, the jury, find the defendant, William Irvin Edwards, not guilty of felon in possession of a firearm in count two. Write your verdicts on a clean and separate sheet of paper. It is not necessary that you sign the verdict. At this time, we'll have closing argument first to state.
This court.
You may proceed.
Ladies and gentlemen of the jury, we started this trial, and I had talked to you about being like a puzzle in pieces. And so our intentions throughout this whole trial has been to give you what you need to see the picture clearly at the end. So what we've done is we've given you testimony, we've built upon that, and we've given you facts and evidence. And what this boils down to is every bit of those instructions are important, but what I want you to zero in on is instruction 4, ladies and gentlemen. That is what the state has to prove. That is what you have to decide on to find this defendant guilty. Ladies and gentlemen, the first is on or about May 1st, 2022 in the 1st Judicial District of Hinds County. That's been undisputed facts. We know that Mr. Davis was killed on May 1st, 2022. You've heard it from at least 5 or 6 different officers. You've heard it from the 911 call, the dates, the times. We know that it was at 216 Hannah, which is in Clinton 1st Judicial District. That's a given. So number 1 has been proven and undisputed by many witnesses. The next part is William Edwards unlawfully and with deliberate design killed Bobby Carlson Davis, a human being. We know that Mr. Davis was a human being. You saw photos of him. You heard testimony about who he was and what he was doing that day. He was cooking dinner for his friends and for the kids. So what you ask yourself is, and we know number 3, so we can skip ahead to it, by shooting with a firearm. You heard the transcript of the medical examiner that he was shot between 6 and 9 different times. And it caused manner of death with multiple gunshot wounds and a homicide. So you heard that, you saw the pictures also. So you know that he died by shooting him with a firearm. So what's important is number 2, unlawfully and with deliberate design. So what you have to ask yourself is, what is deliberate design? So go to jury instruction number 11, and that's what it tells you. Deliberate design is when a person decides to unlawfully kill another person and there's no legally justifiable or excusable reason for doing it. The decision to kill can be formed quickly and may occur only moments before the actual act of killing. However, deliberate design cannot be formed at the exact moment of the act of killing. So think about that. And what you have to think about is, when this defendant arrived at the home of Shadow Robinson, he parked in the driveway, he saw the truck of Mr. Davis, because you said, you heard the testimony, you saw the pictures of the crime scene, that white Ford truck was sitting there. On the side of that truck was his business, with his name, Bobby Davis. He knew that he was there. So what did the defendant do when he got out of his truck? He made sure he had his firearm in his hand, and he went to the door. Ladies and gentlemen, that's deliberate design. That's what he was going to do. Now here's the other thing. When you go to instruction number 7, it says, if death is inflicted upon a person with a deadly weapon in a manner calculated to destroy life or inflict great bodily harm, then malice or the intent to kill may be inferred from the use of the weapon. So what that means is, because he used a firearm to shoot Mr. Davis, you are allowed to infer that he had the intent to kill. That is within your prerogative. That's purview of you as a juror. So ladies and gentlemen, he used a gun as it was intended. It was a deadly weapon. He did it, fired it, pulled the trigger, pointed it almost 6 to 9 times into the body of Mr. Davis. And I use the word 6 to 9 times because we recovered 6 projectiles. We had 6 cases. But remember, I heard the medical center talk about 9 entrance wounds. But think about it. Some of those were flesh wounds through the arm and into the body. So he's got entrance wounds in his body going through him into the chest in certain places. So there's more entrance wounds than there actually was bullets. So that's why I say he was shot 69 times. Now, ladies and gentlemen, that inference is important because that's how you go back to what the state has to prove, which is number 4. Unlawfully with deliberate design to kill Mr. Davis. So, what you ask yourself is, what does the state need to prove that? Well, what did we bring to you? We brought the 911 recording of a hysterical Heather Robinson calling in that her friend Davis had been shot and killed by William Edwards. Moments later, what we had was Detective Fox on the stand that said that he called at like 5:17. The exact time that ping was shown on Highway 80, the exact time that fun time skating surveillance showed that black truck drive by. What's important about that conversation with Detective Fox is Detective Fox thought originally William Edwards. And he says, "Are you shot?" And he said, "No, man, I'm on the road." Okay? That's what he told him. So then we go back and they knocked and they found out across the street, you heard from the man that Wayne Derrick. He heard multiple gunshots. He was a little bit unsure. He calls his wife, he's looking out the window. Elderly gentleman taking care of his neighborhood, inquisitive, looking out, sees a black truck. Is that important? Yes, because it's corroborating where that truck's located. These pings, these cell phones, those are good. The eyewitness testimony to seeing the truck there, surveillance seeing them there. First thing, the next piece of the puzzle is how do you know he was driving a black truck? Testimony of Pastor Wayne Pickett. He let him borrow a black truck. That was his black truck that he let him borrow. He didn't let anybody else borrow it. That's who borrowed it. Said there was no guns in that truck, no ammunition in that truck. That was his testimony. I heard it read to you. That's important because we're still building that case. And then you start getting these pings, and now you're concerned about these pings and locations, cell phones, multiple lines, and are they accurate? They pinged him right there on 80. There was a truck on Highway 80. He told Detective Fox he was on the road. We learned later that there's pings in Lexington. We find out he was in Lexington, Mississippi. Then there's pings again in La Paz, and then there's pings in New Orleans, and then the U.S. Marshals and the Louisiana State Police pick him up at the last ping in New Orleans. They're accurate. They're showing where he is. Now, you heard testimony from the expert who went into great detail about all the pings and locations, showing it from the time before the crime, moving from Jackson to Clinton, and then from Clinton back to Jackson after the crime. You heard a lot of testimony about different things from Greg Jones. We talked about Facebook warrants and Meta from Instagram. You saw the post that was on there. You see what he put for his story. You see the authentications of these records that have come in through AT&T and Verizon. You heard the testimony. They can't be altered. They can't be manipulated. They can't be changed. They just show data points of locations. All of that's important because we have an eyewitness that saw him pull up, no one else in the car. She tells her friend about it. She goes back to her room, and then she hears multiple gunshots. She comes out. She told you she saw the sparking from the bullets coming down the hallway, hitting the door, hitting the ground, whatever it was that's hitting. She sees her friend lying there, bleeding out. And this man, this defendant, William Edwards, standing over him with a gun, and he says, "Gnaw him out. Gnaw him out." She sees that with her eyes. He turns, he walks away, gets in a black truck. She describes light colored pants, white pants, dark colored shirt. They picked him up in New Orleans, dark colored shirt, light pants, black truck. So what it is We have an eyewitness testimony of what happened. And then we built every corroborating piece of the puzzle to show you why what she told you was accurate. That's the truth, ladies and gentlemen. There's no hiding, there's no fascination of misrepresentation, no false narrative, no other insinuation or implication. That is a person's words backed up by other people and other facts so that you can make the right decision. Ladies and gentlemen, the next count that we deal with is a felon in possession of a firearm. And that's your instruction number 5. Once again, we've got to prove where it happened. We all know it's First Judicial District. We all know the time unlawfully possessed a firearm. And he's already stipulated and agreed that he was a prior convicted felon at the time. So 1 and 3 are covered. So the next one is number 2, is did possess a firearm. We showed you the video of him leaving his apartment with a handgun in his hand. We've given you the testimony of Shadow Robinson with him holding the handgun, standing over the tree. We've proven to you this charge, this count, ladies and gentlemen. Now, what's important in all of this is each thing builds upon itself. And that's the thing about truth and corroboration is these pieces fit with each other. Because it's what happened, ladies and gentlemen. On May 1st, 2022, William Edwards got in his truck with a gun with Novex, NOVX, 9mm shells, PPU shells. How do we know that? Because that's what they found. Found PPU shells at his house, and they found Novex shells in his truck, and they found Novex and PPU shells at the crime scene beside Mr. Davis' body. What we know is that he got in his truck. He drove to Shadow Robinson's house unannounced. He got there. He saw Mr. Davis's truck at that house. He used to be in a dating relationship with her. She broke it off. He didn't want it. That was the testimony he heard. He got out of that truck with a handgun. He went to that door. And when Davis came to that door, he shot and he killed him. And he turned and left. That's, ladies and gentlemen, what happened on there. That is the corroborating facts. That is the truth. Ladies and gentlemen, we ask you to use this information, evidence that we presented here at this trial to go back, deliberate, discuss, and to come up with the correct decision that this defendant is guilty of first-degree murder, and he's guilty of being a felon in possession of a firearm.
All right, to the defense. I'll do 10 and 5. 25.
Ladies and gentlemen of the jury, you know, we talked in opening arguments about how did we get here. I told you that most people hate the truth. I told you that there were lies that got us to this point. Also, he reminded you of some great leaders of faith and truth leaders. I told you about Nelson Mandela and his 28 years of suffering in an African prison because he spoke the truth. I told you about Dr. Martin Luther King and how he was gunned down by the range white racists because he spoke about the atrocities that happened to colored people in America. I told you about Malcolm X and how he was killed and assassinated by members of his own religion and people of his own color because he spoke the truth about Islam. I told you that not a few miles from this courthouse, right here in Jackson, Mississippi, our white supremacist named Byron David Beckwith took a .30 caliber rifle and shot nigger in the Shady Oaks neighborhood. And I told you about the greatest atrocity of all time, about a man who told the truth, a man called Jesus. He showed through his declarations, he showed through his signs, he showed through many miracles and wonders that he was the truth, the way, and the life. And they still crucified him. People hate the truth. And throughout this case, every time the truth got ready to be exposed, they objected.
Objection, Your Honor.
Sustained improper argument.
Truth is not popular. Truth has never been popular. Now here we are today, 1,000 years later, after the crucifixion of Jesus on the cross, and people are still mad about the truth. They don't want it. Truth is all that this started with a lie. That's true. All of this started with a lie. You heard testimony yesterday from Detective Anthony Fox and Detective Kenneth Burnett that said that when they first interviewed Shadow Robinson, after reading her Miranda rights, she told them that I shot Bobby Carlton Davis, standing over him 2 times. But you heard the medical examiner. You heard them read the medical examiner report that says that Bobby Carlton Davis didn't have any close range shooting. It was intermediate shooting. It was 3 to 4 feet away. But then you heard Shadow Robinson get on the stand and say she did not see me shoot Bobby Carlton Davis. What's the truth? We don't know, because Shadow Robinson lied. You remember I told you about the toothpaste, right? I told you that lies are like toothpaste out of this tube. Once you squeeze this toothpaste out of this tube, ladies and gentlemen, it's literally impossible to put it back in here. And when Shadow Robinson told that lie on May 1st, 2022 to those detectives, she couldn't put it back in. She couldn't put it back in. She tried, but she couldn't. Because by now, the lie was spiraling out of control. You talk about Clinton, Mississippi. A crime happened. Officers hear this big name. This guy Polo supposedly did something. The guy that's always talking about truth. Well, let's get in behind it. Well, by now, the lie is out of control. They can't put it back together. And all the state has done is try to preserve the lie. They try to preserve the lie. They have not provided you with any proof that I committed this crime. They haven't provided you with a gun, have they? They haven't provided you with DNA, have they? They haven't provided you with any blood stains, any fingerprints. They haven't provided you with anything. All they try to do is preserve the lie. Because they don't want the truth. They despise the truth. You heard Ms. Robinson testify herself. I did not see William Edwards shoot anybody. But you heard Detective Fox and Detective Burnett say that's what she told them at the beginning. And had she not never told that lie, had she not never squeezed this toothpaste out of the tube, we wouldn't be here today. You guys wouldn't be held up in a hotel room for the last 45 days.
Counsel, Ms. Edwards, in proper argument.
What? You heard Detective Burnett and Ms. Robinson, Detective Burnett and Detective Fox talk about Bobby Davis' phone. They asked Ms. Robinson, do you have his phone? She lied. She said, no, I don't have it. But what Ms. Robinson didn't know is that Bobby Davis' family loved him. Bobby Davis' family had been telling him for months, leave Shadow Robinson alone. She's bad for it.
Objection, Your Honor. The fact's not evidence.
Facts not evidence, second warning.
What you heard was that Bobby Davis' family was tracking his phone. They knew that data was being used on his phone. You heard testimony from Detective Fox and Detective Barnett that they went to Ms. Robinson's home on May 4th and found that phone. We know, you heard Detective Jones say that it's possible that things could have been deleted out of that phone. Those are the lies, people. Those are the lies that were told in this case. Those are how we got here. And in the rest of this argument, I'm going to talk about what they presented, what they perceived, but what they didn't prove. Now, they presented some things. I remember I told you in my earlier open arguments about manipulating facts. How people can manipulate facts. That's happening. They manipulate some facts. I reminded you that facts can be manipulated. Fact is that all of us are in court today. But the only one person that's on trial is me. Fact is we're here. Truth is I'm the only one on trial. Think about it, ladies and gentlemen. Every time we try to present the truth, facts are manipulated. Throughout the entire presentation, we rarely object to anything. You know why? Because truth doesn't have to object. It just waits its time. Remember I told you in my earlier open arguments that truth is like love, it's patient, it's kind, it's generous. It doesn't interject itself, it just waits. It waits on you to find it. It waits on you to seek it. That's what truth does. They have not presented any testimony from Ms. Robinson's adult son. They have not presented any testimony from anyone that states I had a problem with Bobby Davis. They have not presented any testimony that says I even knew Bobby Davis. As long as they have not presented you with a weapon. A weapon. They want you to perceive that I had a weapon, but they haven't presented you with one. They haven't presented you with a motive. They haven't presented you with any proof that I even posted anything on social media. But let me tell you what they did present. They presented you with a snippet of a video. Now you heard, you get lights. You heard Ted Jones tell you that I had multiple cameras in my home. People that was about design. I can't even get past my own security. Right here, you see a photo of my jump drive. The light is on. Jump drive is plugged in. It's working. It's recording. You heard Detective Jones state that there were multiple angles in the log. You heard him say that he took that jump drive and downloaded video footage. You heard that testimony on the stand that he did that. They didn't present it. They presented one video, one snippet of all the footage that's on that jump drive. They presented you one snippet. They didn't present you any other angle. They didn't present me coming and going. They didn't present days leading up. They didn't present the day up. They presented you one snippet. You gotta ask why. Out of all the footage that is on that jump drive, that Detective Jones testified that he downloaded, why they didn't show it? Because it's the truth on it. You heard this comment several times throughout the testimony of several officers. This is what they said, ladies and gentlemen. We wanted to protect the integrity of our investigation. You guys remember that, correct? We wanted to protect the integrity of our investigation. Ladies and gentlemen of the jury, what greater way to protect the integrity of the investigation than with video? What greater way? We live in a camera-driven society. What greater way than to protect the integrity of your investigation than to show video? Show him coming and going on the day of May 1st, 2022. Show him with a firearm coming out of his apartment. There's multiple cameras on the day of May 1st, 2022. You downloaded the video. You had custody of it. You saw on the stand testimony I presented Detective Jones with a custody, chain of custody. He was the only one in custody of that jump site. But he didn't produce it. Why? Because they were trying to preserve the life. So the question is, of all the footage available, they didn't produce it. Why? Now let's talk about what they wanted you to perceive. Once again, of all the different angles that my camera offered, they only offered you one angle. Me going out the door with some trash in my hand, and they wanted you to see that the phones in my hand were a handgun. That's it. Who takes trash to the trash bin in a loft in a gated community with a handgun? Who needs a handgun to go to the trash? Make it make sense. They can't. You know why? You know why they didn't show any footage of me coming back in? Because they were trying to preserve the life. Manipulating facts. Let's talk another thing. Let's talk about this truck, folks. You remember the testimony of Detective Jones? Remember Detective Jones talking about the quality of this photo, ladies and gentlemen? Remember how he said, oh, that's a good quality photo. I'm surprised you got it like that. But you remember the moment I asked Detective Jones, what was it that they said that the alleged shooter had on? Black pants, black shirt, white pants. And the moment I asked him to zoom in on that photo right there, you know what he said? I can't tell. Detective Jones literally tried to play on the intelligence of this entire jury that you didn't see what everybody see. That whoever's driving that truck has on a white shirt. Not a black one, as they described I was supposed to have on, the alleged shooter had on. But a white one. That's not the best hanging from there. That's whoever's driving that has on a white shirt. And I'm reminded of a very, very familiar case that we all know about. The O.J. Simpson case. Very famous statement. If it don't fit, you must quit. It doesn't fit. The strength of what let's take a close look at this. I want to look at it. It was his testimony that the alleged shooter had on black shirt, white pants. Look at it. Y'all know what I'm looking at? And he sat here and said, well, it's a glare. I can't see it. Previously in his testimony, he just said, that's a great picture. Now, all of a sudden, when it doesn't seem to preserve the life, there's something wrong with the photo. Well, it's a glare. It's a glare at 5 o'clock in the evening in May. Make sense. And yellow is not white, people. And white is not black. Everybody in here sees what I see. But he tried to play on the intelligence of you, the men and women of this country. Because he was trying to preserve the life. Ladies and gentlemen of the jury, I've talked about the lie that got us here. Talked about what the state did not present, what they did present. I talked about what they wanted you to perceive. But I wouldn't be doing myself a justice if I didn't talk about what they didn't prove. You know, Proverbs 4 says, "In all that getting, get an understanding." I'm asking you to get an understanding. First, they didn't prove that I was at 216 Hannah Drive on May 1st, 2022. They did not prove that I possessed a weapon on May 1st, 2022. They did not prove that I fired a weapon on May 1st, 2022. They did not prove that my DNA or fingerprints are on anything connected to a crime on May 1st, 2022. They did not produce or prove any evidence that I even committed this crime. And they failed to prove any elements of a crime. They failed to prove any movement, that my phones were connected to any area inside the Clinton. All they said it was connected to a town. And finally, they failed to produce or prove that they had any search warrant. Finally, they failed to prove or produce any evidence I was an individual that committed this crime. You know, I told you that in the early opening arguments when this all started some 72 hours ago, that my grandma used to give me a lot of scriptures. She says, the Bible used to always tell, ask and you shall receive. Let me tell you what they didn't ask. They didn't ask my adult children. They didn't ask my daughter, who's an Air Force person, if she owns a firearm. They didn't ask my other daughter.
Sustained. That's not an evidence. Equal availability of witnesses.
I'm sorry. They didn't seek. The Bible says, seek and you shall find. They didn't seek testimony from other people. They didn't seek to interview Ms. Robinson's son, who was on the crime scene. You heard
in proper argument, counsel, witness available to both parties.
You heard Detective Burnett say that he arrived at 6:02, and that Ms. Robinson's adult child was still on the crime scene, inside the crime scene. You heard that testimony. They didn't interview him. They did not knock. They did not ask. They did not seek. They did not knock. They told you, you heard testimony, well, we investigated everybody. We investigated you from the DA. No, they didn't investigate him. He already had been on the investigation.
Objection, Your Honor.
Sustained.
That was testimony.
One more.
Yes, sir. Remember, ladies and gentlemen, you heard a lot about me as a social media influencer. You heard about my popularity, so they say. You want to know how I got popular?
Objection, Your Honor.
Sustained.
We built that platform.
Objection, Your Honor.
Sustained. That's not an evidence.
So let me tell you this. We're going to end this. But I want to end with a story. Is that okay, young? I want to end with a story, ladies and gentlemen. My grandma told me a story last night about a young man named Dick. He was about 10 years old, and he had been living with his grandma for about 2-3 years. And Billy loved grandma's biscuits. She would make them for him all the time. And on this particular day, Billy wanted some biscuits. And Grandma said, well, Billy, I want to make you some biscuits, but I don't want flour. She said, but what I'm going to do, I'm going to turn the stove on. Walk down to the corner store, grab some flour, come back and make you these biscuits. Don't you touch that stove, Billy. So, okay, Grandma. But Billy, being curious like most young boys, went over by the stove, had his little muffin, little hand thing that he saw Grandma always pull the pan out with the biscuits. One of those little gas burning stoves. Billy touched the stove and boom! The glove caught on fire. Billy pulled the glove. And now, house goes up in front of him. But all the time that Billy had been staying with Grandma, Grandma used to tell and read scriptures to Billy and remind Billy, when you don't know what to do, stand on the word. Stand on God's word. House goes up in flames. Neighbors come running out, run down to the store and tell Miss Lowry, Lowry, house is on fire. She So, oh my God, Billy is in the home by itself. But now firefighters responding to the house. House fully engulfed. Laura was standing out there crying, y'all gotta go in, I gotta go in. They said, no, ain't nothing. It's too fully inflamed. She said, my only grandson is in the house. Firefighter looked there and saw the stress in her eyes. She says, we make one last try. Go in. Firefighter gets his gear on, puts his mask on, runs in the house. He's hollering, Billy! 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 They don't hear it. Makes a little corner. He spied a little old closet. Here's somebody coughing. Open the closet up, Billy's standing there on fire. Firefighter picks him up and runs down. He's covered in smoke. And she said, where were you? He says, Grandma, I was standing in the closet on fire. Because you told me when I didn't know what to do, I could stand on the word of God. Ladies and gentlemen of this year, that's what I'm standing on today. I'm standing on the word of God. I'm standing on truth. That you will return to earth. Not on our charge.
My grandmother told me a story too. She said you can put lipstick on a pig, but it's still a pig. And comparing himself to Martin Luther King Jr. or Nelson Mandela or Mahatma Gandhi, whoever he said. And when he said Jesus Christ, the hairs on my arm stood up. I thought we were going to get struck by lightning right now. There's a big difference. He murdered somebody in cold blood, 6 to 9 shots. A person who will never be able to come back to this family. Ever. And we don't get to talk about Bobby Davis, who is left dead, shot to death 6 to 9 times. And remember, he got shot in the backside 2 or 3 times. When the gun shot, I was playing football with my nephew over Thanksgiving. And he got mad at me because, you know, everybody makes fun of each other in football. And we made fun of it when we shouldn't have. He got mad. And I was standing from here to there, and he threw the football at my head, and just instinctively, what do? You know, I turned around. That's what happened to Bobby Davis. The panic. He must have felt. The pain. What a way to die. Left to die, to bleed to death, gurgle to death on the dirty floor. And he wants to school us on truth. Well, justice is coming down his road today. Shadow Robinson said the same thing at the beginning as she has said all throughout in trial. You got to hear. She saw the result and she saw the sparks from this man's gun and him putting that gun in his waistband, walking cool, slowly away. Like some kind of smooth criminal, a murderer. And that's scary. And to look at you people and say the state has offered no evidence. No evidence? Really? No evidence. If anything's insulting, that's insulting. To try to tell you the gun he clearly had in his hand was a cell phone. When you clearly see it. This nonsense about Shadow was somehow hiding the phone. That wasn't the testimony. Her friend had just been violently murdered, killed, basically in front of her, but right down the hall. She sees this man gurgling his last breath in her house. She ain't worried about a phone right now. If the police are asking her about a phone, she didn't know nothing about a phone. When the police came 4 or 5 days later, she told them where the phone was. She's not thinking about a phone. This is a natural reaction that she might have, that she would have. And of course, the law enforcement looked at everybody. That's what good law enforcement do. They don't make snap decisions. You know, it's this smooth, controlled, silver-tongued approach that he knows best. Let's talk about any way to make something when there's nothing. Remember the cross-examination of Shadow Robinson about this truck. Talking about this truck. Well, you say it's what color it is? Well, she said there was some kind of two-tone, like something. And then when she was showing the truck, she said, this is it. Because the bumper, remember, was chrome. I don't know how many questions she was asked about that. Trying to get John Shaw with the geolocation to say there's no evidence of him having the phone. And Shaw said, well, matter of fact, they were with you when you got arrested. Well, then I guess he just said, well, what other evidence do you have? Well, we've got all the corroboration from the pings. We've got the fun time ping, the fun time geolocation that proves that truck was out in front of fun time. You don't have to just believe the picture. Now you've got corroboration of the fun time picture. You've got corroboration he was there. Then trying to insinuate those other bullets found. Well, y'all didn't do the head stamps on those other bullets. Well, brought them in here to do the head stamps. Come to find out they don't match anything. Just trying to get something where there's nothing. Trying to manufacture something. Because when you don't have nothing, that's all you can do. You can just preach. When you don't have the facts, you just got to preach. But you shouldn't preach in the name of Jesus Christ when you murdered somebody. Who has 4 phones and SIM cards in their car anyway? And he can say all day long he was going to turn himself in. But guess what? He didn't turn himself in. Matter of fact, you had the receipt. He got that hotel on the 2nd. He's talking to all these people, all these attorneys, all these police. I'm going to turn myself in. Look at the receipt. It says May 2nd through the 5th. What's he down in New Orleans anyway for? And what about no evidence that I made the post, the Facebook post? My gosh. The Facebook post. No evidence but Facebook. And he even admitted one of the numbers on there was his. He's telling you the day of the murder what he's going to do. And now he's preaching that he shouldn't be held responsible. He's telling you, schooling you, y'all aren't going to convict me because there's no evidence on the stuff. These are his own words. It's not Brad McCullough saying it. It's not the state of Mississippi saying it. It's him saying on Facebook, so says Facebook. No motive. Well, the motive, I think you understand the motive, okay? William Edwards is the old guy. That's the motive. William Edwards is on the out. Bobby Davis is obviously in. Jealousy is the oldest motive in the world for murder. Well, y'all didn't show the video you just showed one snippet of the video here and just showed this. It's kind of like the photographs. I don't know, White said he had hundreds of photographs. I suppose we could have spent 4 or 5 weeks showing y'all every single video and every single, no, we picked the things that is most helpful in showing he's guilty. He's got every right to play any video he wants if he thinks it's helpful. But y'all didn't see that. But it's easy now to get up and say, the state didn't show it. Well, he didn't show it either. It's never enough, is the bottom line. It's never enough. Prove me guiltier than I already am. Ladies and gentlemen, at the end of the day, we would ask you to look at the instructions, see that the eyewitness that we've got to this murder is corroborated extensively by all the other evidence that we've got. We take your job very, very seriously. And when you go back and you have these instructions with you, go through the ones Mr. Guthrie showed you. And I am convinced that you will put all the pieces together. Because at the end of the day, he killed an innocent man over jealousy. Over jealousy. And this family has to live with that for the rest of their life. Have to, when they visit the grave, have to see the date of death, May 1st, 2022. And think about the panic and the pain their son had to go through. This day, we ask for justice.
All right, ladies and gentlemen, you have received the closing arguments of counsel. You may now retire to the jury deliberation. We'll bring the exhibits back to you shortly. Mr. Robinson, if you will get your things and return to the jury room for just a moment, please, for the courtroom.
All right. Jurors out of the courtroom.
All right, you all may be seated. Everyone, please remain in place until all the witnesses speak.
Come this way. That little, tell him come this way. Oh,
Ms. Robinson, you just come back to your box for just a moment. I do want to thank you for your service as an alternate during this trial. I did notice that you were very, very attentive to all the proceedings. We never know during a trial if we have to excuse someone and one of the alternates has to replace us. We did have to do that admission in this case. So I do want to thank you for your service. You are excused. They will assist you in, whatever procedure you want. But you are excused. Thank you. If you just go with, one of the deputies, they'll assist you. All right, I need, someone from each side to reconcile their differences so they can be taken to the jury, for use during their deliberations. Court will be in recess at this time. So you all can do this. has been advised that the jury has reached a verdict in this case. Let me admonish everyone that no matter what the verdict is, there will be no outbursts, there will be no comments or anything said in the presence of the jury. Does everyone understand? All right, let's bring the jury in.
All right. Jurors in the courtroom.
Thank you. All right, you all may be seated. Ladies and gentlemen, the court is now informed that you all do the verdict. Is that correct? Who's the first? You have the verdict. The verdicts are in the correct form. I'll have the clerk to read the verdict.
We, the jury, find the defendant, William Irvin Edwards, guilty of first-degree murder, count 1. We, the jury, find the defendant, William Irvin Edwards, guilty of felony in possession of firearm, count 2.
Would the defense like the jury poll?
Yes, Your Honor.
Ladies and gentlemen of the jury, as I call your number, if you would say whether or not this is your verdict, just by saying yes or no. Juror number 1, is this your verdict?
Yes.
Juror number 2?
Yes.
Juror number 3?
Yes.
Juror number 4?
Yes.
Juror number 5?
Yes.
Juror number 6?
Yes.
Juror number 7? Juror number 8? Juror number 9? Juror number 10? Juror number 11? And juror number 12. Ladies and gentlemen, you are excused at this time.
All rise.
Mr. Lewis, I'll be back with you.
Yes, ma'am. Jurors out of the courtroom.
You all may be seated. The court is going to set something in this matter for next Tuesday at 1:30. Here's they will give an opportunity for the defendant to put forth any witnesses or any other information you want the court to consider. This concludes the matter of State City versus William Edwards. You all may be excused. The deputies will assist you in exiting the building. Thank you.
Everybody go down to the front entrance, let you out the front door.